regulatory visiting procedures. Who really wants to hear about that? You guys must have a lot of time on your hands, or either that, or you're concerned about your organization. This is something that I have a lot of people call and ask questions. Many times it's after they've had a regulatory visit. Hey, OSHA showed up. What do I do? How do I handle this? And so this is a presentation I've done a number of times over the years to help people prepare for a really stressful and a really risky situation for your organization. Our state of affairs right now has really become a regulatory state. We're regulated from one end to the other. Back when I was in the industry, we had dozens of regulatory visits each year, and it was a real challenge. It was really difficult for the average person, and I was employed to keep us out of trouble. And so for the average person to be able to keep up on all those regulations, it's really difficult. And so we're gonna face some regulatory visits. What are we gonna do when that happens? Well, that's going to determine how bad the regulatory visit can be. I'm here to tell you that these regulatory visits can be a positive experience if you handle them in an appropriate manner and you're prepared when they occur. I've had both happen. Had some really bad ones and some really good ones, and I'll talk about both just a little bit. All right. So who's inspecting? We've got lots of regulators out there: federal EPA, state plan, OSHA. So in Utah we have Utah OSHA. Department of Environmental Quality in the state has various divisions, and one of which that is conducting a lot of audits is the Stormwater Division. They're out hitting people, and they're not afraid to levy fines and issue citations. Federal EPA will step right across the state lines and do enforcement actions here. We also have others: DOT, Federal Aviation Administration. If we're shipping dangerous goods or hazardous materials from one place to another, they can step in, and they come in and do regular audits. When I was back in the industry, I would have an FAA visit at least once a year to come in and see if we had our training in place, see if we were shipping those dangerous goods appropriately. And you think, well, we don't do that, but sometimes we might ship an environmental sample that has been had the pH adjusted that meets the definition of a dangerous good or hazardous material, and we have to meet all of those regulations. So, we ought to look at those ahead of time and plan ahead. And then, of course, there's the Army Corps of Engineers dealing with wetlands and also environmental impact statements. Anytime we're dealing with federal money, we have to deal with that, and we can get inspected, regulated on that. I wanted to start out with just a quick statement that this presentation is, nothing personal if there are regulators watching. No offense, this is business. I take this topic as a risk. I work as a risk manager, and a regulatory visit is a risk to my business. It can cost me money, it can cost me reputation, and so it's something we have to take seriously. And that's one thing that's kind of concerned me in our membership is I've visited with a few members out there, and they have a pretty cavalier estimation over, hey, this it's just an OSHA visit. They can't give me a fine; they can give me a citation. What's the big deal about that? Well, these are serious. They're something that can impact our bottom line, can impact us personally, can even put us in prison. And so we have to be very careful about how we handle that. So nothing, like I said, nothing personal towards the regulators. I'm just going to handle this regulatory visit as a risk to my business, and it's a business transaction, so we have to do it in an expeditious way to protect the business. Just quickly want to run through a couple of statistics here. Federal OSHA regulates 56 million workplaces. A lot of people around the country, they do a lot of inspections. not nearly as much as the state plans do. Utah has a state plan. One thing that a lot of us may look at and say, well, hey, there's only about 1% of the workplaces that get inspected in a calendar year. That's going to take a long time for them to get around to us. Well, in a minute, I'll show you some statistics that really reveal that in the state of Utah, if you're a local government, your chances of having an OSHA inspection in the next 4 years are really high. They divide the inspections up based on complaints, high hazard, accidents, referrals. Somebody says, hey, you got to go check this place out. There's different ways that they do that, just kind of a regular rotation for some. Others they're drawn in because of an event or a complaint. So violations from inspections, a lot of those, they're divided up into serious and other. And basically, you can get the idea of what that is. Serious violations takes the bulk of that, and that's federal EPA. Federal OSHA, not EPA. State OSHA plans, there are 22 states, Utah being one of those, that has a state-approved plan. And OSHA's given the ability for Utah to direct their own OSHA program, and that's a good thing for us because it gives us a little more local control and ability to complain if things don't go right the way we want them to go. They do state plans do about 50 to 70% more inspections than federal OSHA. They issue a lot of citations, and they're divided up a little bit different, where OSHA gives mostly serious citations. The state plans divide those up into other and serious and a few repeat citations. Utah OSHA regulates 1.18 million workers, 83,000 work sites. Local governments are included. At a federal level, local governments are excluded from OSHA oversight. And so they don't get looked at as much, and going along with that, we find that the incident rates are much higher for local governments across the country than they are for equally risky jobs in the private sector. So Utah OSHA did about almost 1,000 inspections, just over 1% once again, and they issued about 2 citations for every, on average, about 2 citations for every visit that they made. So just so you know, a citation is a specific, they go into a specific regulation, and they write you were allegedly out of compliance with that regulation at the time they did the inspection. So you may end up with a dozen citations out of a single visit. Like I said before, public entities are a major focus of Utah OSHA right now. About every year, on average, there have been about 40 cities, counties, special service districts inspected. However, recently, the cities have been getting hit very hard. About 60 cities were, I believe it's 56 was the number exactly, were inspected in 2013, and that was double what they did in the years previous. Sorry about that. I was afraid I was going to lose my voice. So why is that? Well, there were some high-profile accidents that happened in local governments, including a fatality, and Utah OSHA said we're going to go out and do some really serious enforcement with local governments, and they followed through with that. They were doing about 28 cities per year. And then they doubled that last year to 56, and we'll probably see that for the near future. When you divide that out, that's about an inspection once every 4 years, or a little bit more for cities in the state. Now, counties and special service districts, you're not on the radar nearly as much as the cities are. However, I can feel it coming. I really believe that they're going to be visiting all local governments as they get through all of the cities. So they gave about 179 citations from those local governments that they visited. If you want to see what people get cited for, you can go to this website, and I apologize for that URL. I will send out the material so you can go to that, but you can go on to OSHA.gov and click for establishment search. Just do a search for that, and you can see any citations that have been issued anywhere across the country. So you can go in and you can limit that just to the state of Utah, put in search words like city or county or district, and find out, hey, what are organizations like mine getting cited for when OSHA goes out. Some of those can be pretty scary. Some of them, people do a great job. That's a good tool. Like I said, in Utah, they have programmed. They'll just plan every year. They're going to do 56 cities. There may be a complaint. You've got an employee that doesn't think things are quite right. OSHA will come out and follow up on that. If you've had an accident, particularly if it's a serious accident, they'll do a follow-up on that accident. They may even do a follow-up regarding your previous visit. Say, hey, things were pretty rough there the last time we went. We want to make sure that things are okay. And I've seen them do that a number of times where they'll come out 1, 2, or 3 years in a row. Here are the most common OSHA citations, top 10 that we see out there. Won't spend much time on that, but you can look at that in your materials when you get those. We want to be prepared before OSHA shows up in a number of different ways. One is record keeping. They're going to ask to see this documentation when they show up. Have your OSHA 300 and associated forms available, and go back. I would recommend having at least 10 years, even though you're not required to have quite that many. I like to be able to show, hey, this is what we've done for a long time, and let them know that, hey, we've been doing the right thing for a long time. Training records. Every time you do a training, or if we come out, do a documentation. Have those attendees sign an attendance roster. Medical qualification for respiratory protection or other programs that are out there. Make sure that we're keeping that data, that medical qualification. And how long do you have to keep that? Well, it's really 30 years after the employee's last day on the job. So that's really documentation you have to keep forever. Exposure data the same way. If you're working with hazardous chemicals, you have to maintain that 30 years plus the last working day of the employee. Reporting. Federal OSHA requires that if you have fatalities or multiple hospitalizations, that you report within 8 hours. In Utah, it's a little bit higher standard. If you have a fatality, disabling, or significant and serious injury, then you have to report within 8 hours. So what is the definition of that? That's it's kind of a moving target. OSHA that's the definition, but when you apply it to real life, sometimes it's a little foggy. If you break your femur, that is a serious or significant injury. If you break your pinky, that is not. If you have an amputation, that's significant. If you have loss of consciousness, hospitalization, those type of things, that would be a serious or significant injury, and you'd want to make that call. OSHA will come out and visit you after that in most cases. However, just on those cases, if you have a question, please feel free to call Doug, Lance, or myself, and we'll help work you through that. And hopefully we can help you make a good decision on making that call or not. Don't call if you don't have to, but if you do have to, make sure you call, because Utah OSHA has somebody that they pay to read the newspapers and watch the websites and see what industrial type accidents happen. If they find one and it's not reported, they're going to call you up and say, hey, what about this? Or you say, yes, it's on my site. They're going to come pay you a visit. Citations. You can get citations for your failing in the state of Utah. However, you cannot get fines. The Labor Commission may not assess monetary penalties against any state agency or political subdivision. So we can't get a ticket, or we can get a ticket, but we can't get a fine. So you say, well, what's the big deal about getting a citation? It's just a piece of paper. Well, they carry with those citations carry with them a lot of baggage. If you're cited for the same thing twice, it could become a repeat, or even potentially a willful violation. That's a big deal. If you have a willful violation, you go to prison for that. It can be a criminal offense. Federal OSHA has come out with a severe violator enforcement program, and what it is an enhanced enforcement program where they go out and they will visit you multiple times. They'll also send out, if you get a citation and they deem that you're in this category, they will tweet out and send out on social media and news releases all about your problems. That's not good for business, not good for public relations. We don't want to be in this category, so let's work hard to make sure we have safe workplaces. If we have concerns or hazards in the workplace, take care of those. We don't want to get into the category of being willful in allowing things happen, allow people to become injured or these hazards to go unabated. Another thing to remember, inspectors remember when they come out and they remember that, hey, you've had a lot of problems in your location. They're going to remember that, and they'll come back the next year to check. Maybe not the next year, but again, they'll come and check that to make sure that you've taken care of those issues. So federal EPA, I'm going to go through this quick. EPA has a lot of reach, about 4,000 administrative orders in a year, millions and millions of dollars of penalties, prison terms. This is serious business when federal or state EPA is involved. Now, that deal about no fines, that doesn't apply to these environmental issues, EPA or state DEQ. And there's some websites here where you can go in and check your environmental record as well, and get information on how you're performing. Uh-oh, I had a little problem there. Sorry about that, folks. I clicked on the wrong place. We're not going to go in and do that. Fines can be up to, actually, I should update that slide. It's $37,000 per day of violation if you're in violation of one of these environmental program or regulations. Now, I work for a company that was actually rated by EPA. This was prior to me working there, and it was another facility back on the East Coast. But EPA went in with their SWAT team, bulletproof vests and shotguns. This company that I worked for, they were actually a military contractor with top secret clearance. They made military hardware and satellite components, and the EPA came in, knocked the doors down, and hauled out a bunch of computers. The allegation was that this one employee faked taking some samples. He falsified some documents, and they ended up settling out, and the guy ended up doing some time for that. There was never an allegation of harm to the environment, but because he had said he'd taken some samples that he didn't take, it was a big deal. So this is not something to mess around with. They're serious about enforcing this. So now that's the scare tactic. Now hopefully you'll pre-plan. Here's some things that would be really important to prepare for your visit. Create a response team. Who's going to be involved if a regulatory agency shows up? Designate that person. Somebody upper management, top levels of management, definitely going to be involved. And you determine who your team will be, but make sure you have sufficient people there to handle this. Make sure they have contact information. So if there's a receptionist or somebody that will receive people at the door, that they have contact information and they know to have this inspector wait until you've got that team together. We can make them wait for a few minutes. Now if they've got a search warrant, they can execute that and go in. But in most cases, we can say, hey, can I have you sit down, and we can take the 10 minutes or whatever it takes to gather the people. Most of the time, these visits are done during business hours. We want to delineate what duties people have, and know what procedures are, so they don't allow a regulator just to walk on the site. I was talking to a member a while ago. They had an OSHA visit. I said, "How did it go?" And I asked some specific questions, and the person said, "Well, I'm not sure." And I said, "Well, were you there when the inspection was going on?" No, we just let the inspector go. Don't do that. We need to make sure that we're going along, that you're participating in this program, because if we allow them the run of the roost, we're gonna probably have some problems. Identify any regulatory documents that you might need and have those available. I like binders. If you can have each media or each program that you've got put together in a binder, so you can pull that out so you're not digging through file cabinets to find what you need. If there are files that are sensitive or ones that OSHA or other regulator cannot see, they're attorney-client privileged or other documents like that, have those stored in a separate location. Get those documents ready ahead of the inspection, and you know, I go back to one of the positive regulatory agency visits I had. I had my binder there. The regulator would ask me a question. Let me see this. Let me see a permit. Showed that. It was easy. The binder had tabs in it, so I could go right to it. By the time I'd gotten through about 3 documents that the regulator requested, they knew that I knew what I was doing and I had the materials available. And from that point on, the inspection went great. They didn't even care about the documents after they'd seen 3 that were absolutely in the right order. And so that's a great idea, is to have that available. This regulator actually even gave me I sent a letter after commending my organization for the good work that we did. So they can be a positive experience. Recommend that you have an inspection kit available. So when they come in, you can go along and have what you need. Have a camera available. Most of us will have that on our phone, but with video capabilities. Most regulators will come in with a video camera, and it will be running the entire time that you're doing the inspection. And so be prepared for that. Think about what you say, and they'll go back and review that video, and they may pull out some things that they didn't see at the time that you were there. Have contact numbers, pens, paper, those types of things available so you can take notes, flashlight, tape measures, those types of things. If OSHA comes in and they wanted a sample for chemical exposures, you should take the equivalent sample that they're taking. If EPA wants to do an environmental test, you should do the same thing. That means that you need to have sample bottles available for taking those environmental samples if you're regulated on water or some other medium like that. Have those available. Take a split sample. That saved my bacon more than once doing that. Most of the time, these inspections will be unannounced. It's actually illegal to tip people off that they're going to be inspected. Occasionally, they may schedule a visit. Depends on the regulator or the agency, but don't expect that. Most of the time, I found that about the time that I ordered lunch or my lunch had just arrived, I'd get the call and said, "Hey, OSHA's here," or "Hey, the inspector is here." But you know, they can come at any time. Inspectors can inspect the premises. However, you can direct them, make sure that they're safe. They're escorted as they go through your facility. They can see certain files and request copies of those. Don't give them the originals. They can take samples, air quality or environmental samples, and they can record information about the observances. Like I said, take a videotape. They can talk to employees, and they can do that in private. You may want to talk to your employees ahead of time and say, here's our procedure when regulators show up. You can talk to them, and that's your right to do that. However, you can give them some guidelines on how to best do that. When they show up, get a copy of their business card. Have them show their credentials so you know that they are who they are. We don't have problems with this in local governments as much as in the business world, but people will go in and identify themselves as a regulator and then do industrial espionage. That's happened actually in the state of Utah. Be polite, but don't offer information at this point. Once they're there, have them sit down until we get our people together. Notify your top manager. Occasionally, attorneys should be involved, but in many cases, I think attorneys really muddy the water, and you're better off to not have them. Like I said, important thing: train the receptionist or whoever might be the first contact with them on what your procedure is. When do you need an attorney involved? If they've got a search warrant, if you've got the Department of Justice, FBI, or some of these guys, your attorney should be notified. Whether they get involved or not is dependent on the nature of the allegations or the activity that's going on. If there's criminal activity engaged, get your attorney involved. However, on a standard OSHA inspection, I prefer not to have the attorneys because it ends up being much more of an ugly visit. Generally then OSHA will bring their attorneys in, and it gets to be more of a challenge. Attorneys, if things are contested, you can bring them in after the fact. Let's see. Important things: treat the inspectors with courtesy and be professional. Be truthful. Don't ever lie to an inspector or misrepresent things. However, yes and no are appropriate, perfectly appropriate answers to a question. If they ask a yes or no question, answer it with a yes or no. Don't elaborate on what might be happening, particularly if you don't know. Don't volunteer extra information. Well, you think that's bad? Boy, you ought to see this over here. Don't speculate or give opinions. Don't be afraid to say, hey, I don't know, or I need to get that information. I'll get back to you. So we want to determine what the scope is. What is this, a wall-to-wall inspection, or are they there to investigate an accident? Was there a complaint? So we narrowed down what the scope of the inspection is. That will help us determine who we need to have, what areas will need to be available. Sometimes we can do it just in the office. Try to limit that scope as much as we possibly can. However, that can change. I've known OSHA to walk in to look at an accident or a complaint, and turn around and say, hey, we're going to change this to a wall-to-wall visit. We plan on a couple of days, and that changes things out. Don't obstruct the inspector. However, I will let you know that you can definitely direct the inspector, walk along with them, and the route you choose to go to where they want to. It doesn't have to be the most direct, or doesn't have to walk through areas you don't want them to be. If they specifically ask for something, take them to that location and don't take them to the rest. That's just asking for more scrutiny. They have a search warrant, ask to see that. Generally in this, you want to get your attorney involved, but don't obstruct. If they come in and they're going to search the place, particularly if they're coming in with guns, allow them to execute their search warrant. If there's an arrest warrant, make sure that's a current employee. Don't impede the officers. Just let them do their job. If it's a subpoena, those should be served at the person's home, not at work. Have an opening conference. Like I said, try to limit the scope, request what they want to see, so then you can bring in people, request or find out what documents they want to see, all of those things. It's important, if you require people to wear safety glasses in your work site, require the regulator to wear safety glasses. Same thing for boots and hard hats and all of that. If you require people to have training before they go into a restricted area, put the inspector through that training. That just goes to show, hey, we understand what we're supposed to do, and we do it. Doesn't matter who it is. Always escort the inspector. My recommendation is have 2 people for each inspector. So then if there's a question, you need to have a runner go to get somebody or get a piece of information. You can send that person off without dragging the inspector through your whole facility. You can also have somebody be a scribe. I recommend that highly, that you have somebody take notes from start to finish, because it's hard to recreate those what we've talked about after, and timelines and all of that. So I recommend having a scribe take detailed notes, photographs. If they take a picture, if the regulator takes a picture, you should take a picture of the same thing, from the same angle and all of that. If they take a video, just the same. Okay. All right. If the inspector notes that there's a problem, fix it. If somebody isn't wearing safety glasses in an area they should be doing that, show good faith and fix the problem. If there's a piece of equipment there's a guard missing or it's damaged, take it out of service while you're there. That shows good faith, and hopefully that will bear fruits later on in the inspection. Maybe you won't get a citation, or maybe it won't be as serious a citation. Like I said, if they take a sample, you take a sample. So documents. Inspectors can request copies of documents, but it needs to be within the scope of the inspection that we're doing. If they're asking for a ton of documents, make sure that you say, hey, this is going to take some time. Give me a list and we'll make copies. Never let the inspector take your original documents, because most likely you won't get those back. Don't ask me how I know that, but it has happened before. If there's a question as to whether a document is something the inspector can see, ask an attorney. There are certain attorney-client privilege documents that are not eligible for those inspectors to look at. Have a closing conference. When you're all done, sit down and ask about what were your findings, what was there. If they don't understand what your process is, or they've got confusion, clarify that. Clarify any misunderstandings that are out there. This is not the time to argue or debate about whether there's a non-compliance or not. It's also not the place to agree that non-compliance has taken place there. You want to take this time to explain or summarize what you have done to correct. So if they noted a problem out there, say, yeah, there was remember that machine that was missing a guard? We put that out of service. We pulled that extension cord that had tape on it out of service and cut it and threw it away. Let them know that, hey, we've done our job to remedy these things, and hopefully they'll take that into consideration. Like I said, resolve misunderstandings, clarify any actions that need to be taken. If they say this is an issue, say what needs to be done to abate that problem, what needs to be done to take care of that, and clarify what they're looking for, because sometimes they don't understand exactly what it is we do, what the process is. Ask them to identify suspected violations. They generally aren't going to say you are in violation of the Clean Water Act or this part of the OSHA Act. So take time though to ask them, what are your concerns, and what do we have to be concerned about, so we can get to work on it before a citation shows up. If they ask you to sign anything, ask your attorney, just a phone call there. After you're done, make a summary memo so upper management, whoever it may be, knows what has happened. That's where those notes that we've taken along the way can really be helpful. Draft that as an attorney-client privilege document listed as confidential, and also as a draft. And that needs to go to upper management as well as your attorney. Don't include any conclusions or opinions of, yeah, we got caught on this one, or yeah, this wasn't right. Just give the facts as to what you observed, and then send that on. We don't want to make any opinions at this point, or conclusions at this stage of the game. Follow up. If there's a problem, fix it. Go out and find out if you need support, legal or technical support. Get that support there, and track those items to completion. We want to have any concerns taken care of before we get a letter back, a violation back from the regulator. Let me go back here. So if you do get a notice of violation, make sure you hit your time frame. Make sure that you've covered those things, taken care of them in the allotted time frame. Almost always there will be a due date on that. So if you get a letter, make sure letters from regulators are serious business. Make sure that top management is knowledgeable that you're having communications with regulators. Make a copy of all of that. Anything that you send to a regulator should be copied, and it should also be sent certified mail, return receipt requested, so then you have proof that yes, that document was sent and they received it. What if you get a citation? Well, that's a bummer. It happens. I've received citations over the years, and it's no fun. But it's something that we just have to take as business. We need to fix the issue and make sure it never happens again. Citation lets you know that there is an allegation that you violated one regulation or another. For OSHA citations, you need to post a copy of that citation near the area where it was allegedly occurred for 3 days. And you can request an informal conference if you don't agree with what that citation said. Basically what that is, you can sit down with the compliance officer as well as the manager for the department and plead your case and say, here's what happened. You didn't understand this, or we don't agree with your conclusions here. And you can sometimes have citations completely removed, sometimes dollar values of fines reduced, and it's a valuable thing. I don't always do an informal conference, but many times I've been able to explain things and have a much better outcome. Contesting citations, there's a formal process, and this is where the attorneys get involved. If you don't agree, don't come to an agreement in your informal conference, then you can formally contest that. Remember that there are time limits on that, and so you have to get your notice in soon. Employer has various rights here. I'm getting a little bit short on time, so I want to run through these quickly. You can request an inspection warrant, a search warrant. However, I don't recommend you do this, because if they have to go to a judge and get a warrant to come in and look at your facility, they're not going to be very happy when they come back, and the result of that outcome or of that inspection is going to be ugly, probably. So I would highly recommend that you don't require a warrant for them to come in. And you have the right to be advised of why they're there, what they're looking for. You have the right to have an opening and closing conference. Now that can be a very formal thing, or it can be a little less formal, but you should always have a opening and a closing conference. So you identify what we're worried about, and at the end, or identify what we're looking for, and at the end identify any concerns that they have. And you have the right to accompany compliance officers and be with them, and you should do that. However, employees do have, regulators and employees have the right to meet in private. You can request an informal conference, file a notice of contest. You can sometimes apply for a variance from the standard if you have an odd situation. Employees have rights to have access to certain materials and to have a safe workplace. They can talk with the regulators, they can request an inspection, and they can get whistleblower status. And if you retaliate against them, you can have some legal action taken against you. So to prepare for this, we want to use a team approach. Don't just say, hey, this person is over regulatory affairs. Everybody's involved with this, so make sure that we're working together as a team. We establish this is the regulatory team. Now, what applies? Look at your legal requirements, write those down, and come up with a plan. How do we always maintain compliance with that? Identify if you've got areas of concern. We're constantly harping on putting up, doing regular inspections of our facilities, so we know what the areas of concern are and take care of those. So when the regulators show up, we don't have anything to worry about. Okay. Document, of course, is important. I worked in a highly regulated industry, or several industries, but one that I worked at, we went through and identified every regulation, both state and federal, and wrote where that applied and what we were doing to meet compliance with that. Tracking things to completion. We'll plug our MyTrust app again. If you use that, you can go out and get everybody in your organization involved. It's available on the mobile application. Is the best way to get the information in there. But once it's there, anybody can access that over a web interface, and you can have complete visibility over how quick these things are abated. These are for your regular monthly inspections. All right. We ran through that fairly quickly. Just in summary, these inspections can be a positive experience if you plan ahead. If you've taken care of your issues ahead of time, you're prepared to give the information that they request. The documents are available. It could be a positive experience. Like I said, I've had good and bad from this, from regulatory visits. Luckily, the last, I don't know how many I had, were all very positive. So I appreciate everybody's attendance today. And Doug, do we have any questions out there?
How's that for the lady?
Hey, there you are. I've got you now. I'm going.
No questions here.
Oh, let's see. No questions. Looks like we just had some questions had some audio difficulties, a couple of folks.
Yeah, I had one that had some audio difficulty.
Okay. Well, very good. If there are no questions, we'll wrap it up. I appreciate everybody's attendance today. And if you've got questions about this, I'd love to talk to anybody about how to go about preparing for this. We will send the slides out and post up the recording of the webinar to our website. That may take a couple of days to get up there, but we'll make it happen. Thank you very much. Everybody go out and have a safe day.